We continue to read the divorce case of Mrs. Moureen Sinclair versus Mr. Wesfore Sinclair. We're now at submissions on behalf of the claimant, Mrs. Sinclair. Counsel for the claimant, Mr. Steer, who is Mr. Sinclair's lawyer, submits that Section 7 of the Property Rights of Spouses Act is applicable in these proceedings. He is of the view that there is a basis for varying the equal share rule with regards to the family home. He accepts that the property in dispute is the family home of the parties, as it falls squarely within the definition of a family home defined by Section 2 of the Property Rights of Spouses Act. So here, as to whether it is a family home or not, that is not in dispute. It is the family home. And remember, you may find yourself, or you probably are, going through a divorce right now. These are some of the things that you should look at as you contemplate filing that paper, or you're preparing yourself for your spouse to file that paper or those papers. Remember, you must prepare for these things. You cannot control what other people do, including your spouse. So, here, the family home. The house is indeed the family home. That's one. All right, we continue. He has advanced various reasons in support of his position that the equal share rule should be varied. I guess he wants Mr. Sinclair to get less than half. Okay. Anyway, he states that Mr. Sinclair has not, by any of his affidavits filed in these proceedings, stated that he believes himself to be entitled to an equal share in the property. So in your affidavit, you must file that you are entitled to equal share or whatever share there is. So you see, that's one of the things that Mrs. Sinclair's lawyer is bringing up. He makes reference to the portion of the defendant's affidavit, that's Mr. Sinclair's affidavit, which states, the claimant has offered to place my name on the title as an owner, but I decline that offer. So now Mrs. Sinclair's lawyer is using that to try to reduce the amount that Mr. Sinclair is entitled to, preferable to zero, because Mrs. Sinclair wants the entire property. Right. Counsel says that he appreciates that the provisions of the Property Rights of Spouses Act prevail over common law principles, which, with regards to transactions between spouses, however, relying on the case of Suzette Anne Marie Hugh Sam versus Quentin Chin Chung Hong Sam 2018, he suggests that there are instances when the intention of the parties should be considered. He submits that it is evident by the language of both parties in their affidavit, evidence in these proceedings, that the property was treated as the claimant's, that is, as Mrs. Sinclair's property, though the defendant, Mr. Sinclair, assisted with the maintenance and improvement of the same, he is willing to relinquish any interest he may have gained. Counsel advances the argument that between 2004 and 2010, Mr. Sinclair borrowed the sum of over $45 million against the family home, fallaciously stating that the sum was used solely to construct the dwelling house on the claimant's land, on Mrs. Sinclair's land. See the way the lawyer put it, on Mrs. Sinclair, the claimant's land. But the sum was also injected into several businesses owned by the defendant over the years. So he's saying that Mr. Sinclair used Mrs. Sinclair's land to borrow money for his own business and not for constructing the house. That's what Mrs. Sinclair lawyer is saying. Counsel is of the view that Mr. Sinclair, the defendant, has given no evidence in this matter that Mrs. Sinclair has access to the monies from the mortgage. So there is no evidence that Mrs. Sinclair has access to the monies from the mortgage, nor the source of his funding for his business ventures, nor how the mortgage loans were expended over the years on the construction of the property. So that's what the lawyer now is saying, that he's suspecting that Mr. Sinclair's businesses were funded with money that he borrowed from the bank using Mrs. Sinclair's land title. He takes the position that the defendant had the benefit over the years of utilizing the claimant's title. So Mr. Sinclair had the benefit of using Mrs. Sinclair's title in order to fund and expand business ventures. This has assisted Mr. Sinclair in becoming a man of great wealth, and as such, any share Mr. Sinclair may have in the subject property has been paid out to him several times over, whether directly by the share he received from the mortgages or indirectly by increasing his earning capacity several times. So he's saying that Mr. Sinclair has already benefited from Mr. Sinclair's land, so he shouldn't get anything, presumably. As it relates to the outstanding mortgage on the Cherry Gardens property, relying on Section 17 of the Property Rights of Spouses Act, counsel submits that the court should find that the defendant, Mr. Sinclair, is solely responsible for the discharge of the same. That's the outstanding mortgage. So he's saying Mr. Sinclair is the one who should pay the outstanding mortgage and not Mrs. Sinclair. Well, this case is getting even more interesting. He relies on the case of Bellboot versus Bellboot 1992 and Wilson versus Wilson 1991 to say that there was no element of togetherness or common venture in relation to mortgage loans so as to find the claimant, Mrs. Sinclair, equally responsible for their repayment. He submits that although the loans were signed by both parties, they were not at any stage ever considered by the parties to be joint loans or taken in the course of a joint venture. Counsel says that though the claimant, Mrs. Sinclair, herein possibly benefited by virtue of her maintenance received from Mr. Sinclair and the continued construction of the matrimonial home, these fruits, as stated above, do not mean that she is equally indebted. However, Mrs. Sergio, so she's now using her maiden name here, or the lawyer is mentioning her maiden name and not her married name. Mrs. Sergio, did not benefit in any way, as indicated by her affidavit, though she is a shareholder of Pines Imaging Center Limited. Imaging Center Limited. Or they repeat the Imaging Center Limited here. Anyway, she has never received a share of profit from the same. The loan and its consequences were at all times the responsibility of Mr. Sinclair and by extension the companies that benefited from them, having acknowledged that the debt charges or charge against the property are his sole responsibility. Those debts clearly fall within personal debts as outlined by Section 17 of the Property Rights of Spouses Act. So this attorney doesn't want Mrs. Sinclair to be responsible for any of those loans. Mr. Sinclair, he says, would be the only one responsible for repaying those loans. We will look at submission on behalf of the defendant, Mr. Sinclair, in our next video.